Hello, thanks for joining us. This is TVC News at 12. We start off in the nation's capital, where Justice Binta Nyako of the Federal High Court has withdrawn from the trial of IPOB leader Nnamdi Kanu. Justice Nyako's decision followed an earlier request by Mr Kanu asking her to recuse herself from the trial over allegations that she refused to obey orders of the Supreme Court. Nnamdi Kanu's file will now be sent to the Chief Judge for reassignment to another judge. Mr Kanu earlier ordered his counsel, Mako, to sit down while he stood from the dock to address Justice Nyako.
As long as justice will be done at the end of the day, that's what bothers me. For justice to be done. I cannot be tried in violation of a key provision of the Constitution of Nigeria, Section 36. It's as simple as that. The Constitution of Nigeria says any determination made by the Supreme Court is binding on a lower court. So I was actually surprised that a high court have refused to obey or abide by the determination of the Supreme Court judgment.
Let's get more details on what transpired at the court today. TVC News judiciary correspondent Celestina Aria joins me on the news. Celestina, a twist of events in court today. Give us more update on this.
Well, Precious, today's proceeding took unexpected end because Mr Kanu asked that he can keep herself in the and we know Mr Kanu was rearranged in 2021 when he took his plea and pled not guilty. But for easy understanding and sometimes I have Mr Kanu's lawyer, a team of lawyers actually, about speaking to our lawyers who represented him in court, who took the lead in court today, to give us more insight as to why his client took the decision of asking Justice Binta to recuse herself from the trial today. So, Mr. Kanu told Justice Binta that he doesn't have confidence in the court. As his lawyer, do you agree with his position?
Yes. With what happened in open court today, we tried our best as his legal team to advert the attention of the court, call the attention of the court to the infirmities in the proceedings. The constitutional infirmities, very serious, very grievous constitutional infirmities that are militating against preparing him for fair trial. In particular, the breach, the flagrant breach of Section 36, rights to fair hearing, which were not being properly addressed by the court. We wanted those infirmities to be removed, those features, those things that are making it impossible for this trial to proceed fairly to be removed before Kanu could be put to trial. But my lord, the court was very reluctant to do that, and the court was blinded by some reasons in its wisdom to proceed with the trial when Mr Kanu has not been given the opportunity with his counsel, team of counsel, to prepare him for this trial at the detention facility, DSA detention facility. So we felt this is unconstitutional, but the court was blinding itself to that. So our client had no choice than to express himself. That is his constitutional right. And remember that historically the Supreme Court had questioned the impartiality of this very court. So today it appeared that the Supreme Court was right after all.
But if you look at what Justice Binta said, she said that the part of the judgment where Mr Kanu anchored his decision or his outburst in court for her to recuse herself was a contributory judgment, not the lead judgment. That judgment was made by Justice Emmanuel Aogi, and that is what he's basing his decisions for her to recuse herself. So what is your take on that?
Well, she did not say that on the record. When we applied for restoration of the bail, we made the argument that this is part of the lead judgment. The opposing counsel made a contrary argument. She never made a ruling on that. She dodged the question. She never made a ruling. What she said in open court today was a surprise to us. The issue whether the judgment, that part of the judgment was an obiter dictum, or whether it was part of the lead judgment or whatever, they raised the issue for the prosecution. We addressed it. When she made her ruling, she dodged the issue. Rather, she went abroad to say that she had previously forfeited the bonds that protected the bail that he had given to him, and that forfeiture was a question before the Court of Appeal, which also was in error. So we went on appeal. If she had addressed this issue on the record, that it wasn't part of the lead judgment, we would have taken it head on.
Okay, lastly, sir, remember your client has always complained that he had health challenges, hearts, and thereafter. And now that the court has said that this case will be sent back to the CJ, don't you think it will take time? Because Justice Binta said that the CJ is unavoidably absent from the court. So the time before the court, the file gets the CJ and gets reassigned to another judge, does your client have that time in his hands to wait for the court to sit again on this matter?
Well, you have had this saying that it's better for 9 innocent men to go free than for 1 guilty man to be convicted. So we are here in search of justice. Sometimes they say justice delayed is justice denied, but not always. There are exceptions, and this one happens to be one of them. We are willing to wait for the chief judge to assign the case to a judge that will see the justice of this case, that will open his or her eyes to the justice of this case that this court has failed to do so far.
Thank you very much.
Thank you so much. Thank you. Thank you.
The case to be sent back to another judge. Soho was willing to send the case back to another judge so that the trial can commence. Well, before what the counsel has said, they have raised issues as to the jurisdiction and also the bill. Both these issues have been filed at the Court of Appeal, which will also brought before Justice Binta Nyako, asking that she adjourn the matter pending the outcome of the Court of Appeal's decision. But this was before she recused herself. She also said that according to the ACJ in criminal proceedings, they cannot be still proceedings or an adjournment.